Securities litigation, by definition, is complex. There are a myriad of state and federal requirements that have to be met, for example. And if those requirements are not met, or the law is not followed by somebody, and there's a private placement, for example, or a public placement, then it creates a little bit of a dilemma for the plaintiff or the defendant in the case, because a lot of it is expert testimony driven, and there's also factual studies as well. And I'm referring to cases where there's a technical issue, a failure to file a form with the SEC, for example, or a failure to give a disclosure to an investor, or a failure to give an accredited investor an investor questionnaire. In the cases of fraud or allegations of breach of fiduciary duty, that's actually a little bit easier, because it's more provable to the extent that there is a material misstatement or omission. And so that is a little bit easier to try or arbitrate. The cases that involve complex disclosures, those can be challenging and require a lot of expert testimony. So that's a long way of saying that securities litigation is time-consuming, expensive, and often unpredictable, and it's driven in large part by complex statutory schemes at the federal and state level. Our firm has handled several notable securities cases in different contexts. We've handled cases as a plaintiff. For example, on behalf of a client, we had to sue an investment advisor who we discovered defrauded the client out of $3 million. We were successfully able to obtain a judgment against that investment advisor and recover a good portion of those losses for the client. On the other hand, we've defended companies that have faced allegations of securities fraud or breach of fiduciary duty in connection with securities offerings, and we've been able to successfully defend those cases to judgment, or in other instances, settle those cases at a nominal settlement value to the plaintiff. So we've had experiences on both sides of the aisle as the plaintiff and as the defendant in a wide area or myriad of securities litigation issues. If I were a company that was faced with a securities litigation matter, or an SEC matter, for example, I would look for counsel that is A, familiar with the securities laws, has the experience and training and understands them, and B, really understands my business and what I do, because that will really drive the defense of the case. And having an advocate who has the underlying education, training, and experience, but also takes the time to understand my business and what it is I'm trying to do, and what my objectives are, will ensure that I can mount the most vigorous defense possible under the law.